Pune. I work with Vivek, who's also in the audience. So, marriage equality, as it's popularly called in the media, and what we did and what was the scope of the C-HELP's intervention with the Supreme Court. Um, So this is a brief background to how C-HELP got involved in the Supreme Court cases. In 2021, C-HELP published this report, Happy Together. And this report actually came in response to the cases that were already pending before the Delhi High Court and the Kerala High Court. 2020 onwards is when people had started filing several petitions before the Delhi High Court asking for marriage and consequential rights flowing from marriage. For example, transfer of property, tax implications, and those other things. And that's when Vivek and I first had a conversation about how after Nalsa and after Navteej Singh Johar, when recognition of gender identity and decriminalization of same-sex conduct had happened, these were not necessarily the first issues and conversations that a vast majority of the people in the community were actually talking about, that is, going towards marriage. But there were so many other issues. For example, we've talked about how trans and intersex people have fought for social economic rights across several high courts since 2014 and especially after 2018 as well. So in that context, we felt focusing on marriage was a bit of a misprioritization of the community's interests, and then we wanted to refocus the conversation towards broader. So that's what the report does, where we talk about going beyond marriage, because if you look at marriage, some of the key foundational principles that underline marriage is that traditionally that you have to be heterosexual, you have to be within the binary of gender. It's a conjugal relationship, and it's a monogamous relationship. So the marriage equality, quote-unquote, petitions that were pending before the Delhi High Court, Kerala High Court, they sought to challenge just two aspects of these four issues, which is to say that it should not be limited to heterosexual couples, and it should not be limited to people within the binary of gender. That is, queer and trans people should be allowed. However, the issue of conjugality and monogamy of two people in a intimate romantic relationship is left untouched when you're talking about marriage per se. And if you go back in the 90s and you look at so much literature and advocacy is already done by queer and trans people in terms of talking about how marriage was always one of the issues on the agenda, but it's not limited to marriage. People are talking about recognition of diverse form of kinship networks, not only monogamous, not conjugal also, talking about an association of, broader association of families that includes queer, trans as well as heterosexual people who choose to live together, and instead of these four principles that we just outlined that underline marriage, the basis of such diverse kinship networks is caregiving, economic interdependence, there's an element of economic interdependence, and there might or not be shared domestic responsibilities. So any two persons or any number of persons choosing to care for each other, provide financially for each other, and share domestic familial responsibilities should be recognized as valid families in law and protected, and rights flowing from such recognition should accrue to all parties in terms of child custody, organizing families, tax benefits to family members, transfer of property, healthcare decision making, etc. So this is what we try to outline in the report Happy Together, which was published in 2021. As a consequence of that, in 2022, a lot of lesbian, bisexual, trans and intersex networks got interested in reviving these conversations again and wanting to divert attention away from just marriage to broader social economic rights. So we had a national meeting in Calcutta in June 2022, and we had a regional meeting of Maharashtra, Karnataka, Gujarat, queer trans people, um, where marriage was just an incidental discussion, but some of the issues that weigh on people's minds heavily that came through the discussions, which were also articulated in the report, are in terms of protecting queer trans people from natal family violence, because even after 2018, where same-sex conduct is decriminalized, you see queer trans people running away from homes constantly and going to the High Court to seek protection. So the conversations and the consultations focus mostly on that you can't allow a status quo like this to be, where to seek a life free from violence, you constantly have to go to the High Court, which is economically not possible for a vast majority of people. So this is one issue. In terms of broadening the issue outside of marriage to talk about chosen families, where you're talking about any number of persons who choose to live together and have formed families, and where caretaking and financial interdependence, shared domestic responsibilities are defining features of those relationships. This should form the basis of legal recognition of LGBT families, not just monogamous conjugal marriage. So it's actually through these conversations that when towards the end of 2022, that the Delhi High Court and the Kerala High Court cases were starting to get transferred to the Supreme Court, is when the people that we were in conversation with and consulting approached C-HELP again and said that now that the Supreme Court is going to issue a decision and decide the matter, we should go to the Supreme Court and file a case so that our voices are heard and we can broaden the scope of the hearings to bring forward all kinds of issues. Not just issues as has been referred popularly as those limited to metropolitan, upper class, upper caste people. So this is actually the start of C-HELP's intervention in the Rituparna case. So we'll first talk about who are the parties and then what are the issues that we raise. So in terms of the people that we represented in the Supreme Court, the petition is called Rituparna Bora versus and others versus Union of India. So our petitioners include 3 couples who've already had a history of conflict with natal family, where they've run away from families due to violence and faced different degrees of violations, from psychological trauma to threats of forced marriage to corrective rape, and where parents have filed false cases to regain their adult children's custody so that they can be separated from their queer or trans partner and be forced into heterosexual marriages. So we represented 3 couples, and lesbian mafia is a reference to 4 queer feminist activists who were part of the petition as well, which is Chainika Shah, Rituparna Bora, who is the lead petitioner. Chainika was part of Labia for several years. Now they formed a new collective called Hasrate-e-Zindagi Mamuli. Rituparna Bora runs Nazariya, Maya Sharma, the writer, and Meenakshi Sanyal, who runs Sappho for Equality in Calcutta. And all these 4 queer feminist activists have also handled a lot of crisis cases. So that history of, they've not only written about it, but they've also provided support services in terms of interventions at the police station level or going to high courts to seek protections for queer trans people who run away from homes. As well as they've published a lot of literature on that. So a lot of this experience formed the bedrock of our petition before the Supreme Court to talk about, to contrast what the other petitioners, original petitioners who first came to the courts were talking about, which is that we are all rich and happy and our families accept us, but the only problem in our lives is that the law does not recognize our relationships. And that is how then, court's reliefs would also be influenced. So the idea before the court ordinarily would have been to just reinterpret laws and say now people can marry and everything is all right. But when you ignore the history of natal conflict with queer trans people, what leaves out is that people who are more marginalized because of their class, caste and gender identity backgrounds need additional layers of protections in law, which only marriage cannot provide. So that was the main underlying basis of the petition. The prayers in terms of, in terms of what the intended outcome before the court we want it to be, which is known as prayers in law. The first prayer, obviously, to get our foot in the door before the Supreme Court is to say that the Special Marriage Act, which is the only secular marriage law in India, should be interpreted in a manner so that queer and trans people are allowed to register their marriages under the law. Related to that is this aspect of notice, domicile and objection framework, which we'll come to towards the end. This is part of the Special Marriage Act. Then going beyond marriage, then we go into the unique issues that the Rituparna Bora petition underlines, starting with a declaration from the court to say that queer trans people should be allowed to form chosen families, not just marriage, but even chosen families. And a consequence of the recognition of chosen families should be that single people, those who don't choose to marry but have chosen families, then such single people should have the authority in law to nominate the members of the chosen family in terms of any social, economic, civil rights that accrue as a consequence of residing together as a family. And lastly, we talked about having a national protocol to offer protection to queer trans people who face violence from families and run away and need safe shelter homes. So with this, we filed a petition in February 2023, and 18th April 2023 is when the Supreme Court began hearings in the matter. I'll just touch upon some key aspects of what was argued before the court, both in our case as well as the other lawyers. So one of the issues is that on day one itself, because several people had also filed marriage petitions not only under the secular law but also to seek marriage under Hindu law. And as a compromise to the government, the court agreed to drop personal law from the scope of the hearings, so that at least one aspect of legal interpretation of the secular law would go through smoothly, apparently. So they were very conscious that we don't want to deal with personal law because that's a more sensitive subject for the government. But the complication over there is that the secular law on marriage, which is the Special Marriage Act, itself has a interplay with personal law with respect to succession to property, and how that played out and what complication it gave rise to, we'll discuss subsequently. Other interesting issues that came up is, so the court seemed to be very agreeable at the start to say that queer trans people, whether married or unmarried, should their rights should be protected in law. And one of those aspects of rights arising out of such relationships that the court was fully on board with right from the beginning is adoption. But when pointed out that only married people are allowed to adopt and single persons can adopt, that's when the court started also talking about thinking out loud that yes, so if we have to allow queer trans to marry jointly, then we have to recognize marriages. But however, if we don't allow marriage, a lesbian couple, for example, one partner can still singly adopt, and both parents can then be the parents, legal parents in that situation. But it came up in arguments by one of our Central Adoption Resource Agency, which is the statutory body under the regulation adoption law in India. They've passed a circular in 2022 June to say that single people seeking to adopt but who are in live-in relationships should be disbarred from adoption because only married couples form stable family units. Therefore, even single people who are in a live-in relationship should be discontinued. which was until up to June 22 not explicitly barred or prohibited. So now it became a higher duty on court to say that either we definitely have to legally reinterpret the Special Marriage Act to allow for marriages so that lesbian couples, for instance, can adopt, or we have to say that marriage or marital status should not be the basis for seeking rights at all, which is something that even we had talked about. And lastly, the arguments that we raised before court in terms of chosen families and protection from violence. So, while what we are talking about, the recognition of chosen families sounds like a novel idea in law, our job in court was to convince the court that it's not really so radical or new, technically speaking, in law. Because if you look at the adoption law itself, the concept of adoption is that typically a married couple has chosen to bring a non-blood related tie within the family fold, and once that act has been recognized by law, this as the legal child and possesses all rights as a natural child for all intents and purposes in law. So we were trying to argue for the court that this is nothing but already a recognition of chosen family in law as early as 1956, where the law has already delinked the idea of sex and blood to form families, where heterosexual couples, Hindu heterosexual couples under the Hindu Adoption and Maintenance Act 1956 were allowed to bring in children within the families. It's dark. The Mental Healthcare Act 2017 also is a very recent and good example of recognition of chosen families, where the law recognizes that a person living with mental illness can appoint, quote unquote, any person to take decisions related to healthcare on their behalf. And so when you, the law also clarifies that any person is not limited to relations by marriage, blood, or adoption, which means, in a way, chosen family, say your friend or any other person of vital importance in your life, can be that person who can make those decisions on behalf of a person with mental illness. And this is also, if you look at the government parliamentary standing committee reports, you see how this was controversial at first. Several healthcare practitioners themselves advised against it, but the government actually defended this to say that such kind of delinking of rights away from natal family is essential to protect people in vulnerable positions. So then we argue that if one kind of vulnerability is recognized to go beyond the natal family, we are talking also similarly situated vulnerabilities on account of sexual orientation and gender identity, which merits recognition of such family members. And then there are court decisions where, for instance, Hijra Gharanas are recognized as a legal entity in law, where if one person from the Hijra Gharana dies, the surviving members of the Gharana are treated as legal heirs to succeed to that person's property. And that is recognized on the basis of the Guru Chela Parampara that such Gharanas live with, which is distinct from your Hindu, Muslim, Parsi, Christian personal law. This is again a recognition of chosen families in law, because that link from sex and blood has been broken in law repeatedly. So this is what we were trying to convince the judges, because this was a very new and different issue we were bringing before court apart from marriage. And in fact, one of the judges, Justice Ravindra Bhatt, actually caught on to this aspect and found it interesting and asked us to present more material for the judges to consider on the different ways in which trans people have lived and formed families in India, which we did present to them the next day. Sorry, just go back for a second. This report, Apno Ka Bahut Lagta Hai, is a report that was done in days leading up to the Supreme Court hearings by PUCL and the National Network, who were the petitioners in the case. And the purpose of the report was basically to highlight questions of law that we were raising within the petition, so that once the hearings began, the court and media attention is not just drowned only in talks of marriage. So this report, which is published on 17th April 2023, one day before the Supreme Court hearings, is also available. I've provided a link to both the reports that we've discussed. So now we go to what the government argued. The image is basically supposed to illustrate that the government's arguments were steeped in homophobia and transphobia. But in the first 2 days, when the court, the bench, tried to shut down outrightly homophobic and transphobic arguments, that's when the government came up with much more creative legal arguments to defeat our case. I mean, as just one illustration, the Solicitor General tried to scare the judges on the aspect of legal recognition of gender identity, to say, because we were talking about recognizing marriages of queer as well as trans people. And we had presented a very reasonable formula for the court to reinterpret the law. But the government, the Solicitor General, read out from an unverified, unsubstantiated website that there are 72 gender identities. If the Special Marriage Act, if any Indian law is supposed to be reinterpreted and accommodate 72 gender identities, which change from morning to noon to evening, which are dependent on mood swings, so outrightly homophobic and like just offensive. The court eventually stopped the Solicitor General, and then that's when they came up with more legal responses, which is, it was informed by homophobia and transphobia only, but they did a good job in presenting secular sounding arguments, which is basically to say that if you change not just the marriage laws, but all other laws to include queer trans people under Indian law, then this will disrupt the whole legal system. It will not only create confusion within the Marriage Act about who is the wife, who is the husband, as the government argue, but it will also create confusion in other secular laws. For example, there are gender-based violence laws that are made for protection for women, both single women as well as married women. So for example, section 304B of the Indian Penal Code talks about dowry deaths. That if a married woman has died within the first 7 years of the marriage, it is presumed in law that the husband and the relatives are involved in the wife's death, and so the investigation should start in that direction. And so when the government was arguing this, the court actually got very nervous, and they actually started buying it, and they started discussing that, and by they I mean the judges. Now the judges were thinking about things like, if it's a lesbian couple who's married and one of the women has died, so how do you interpret dowry death laws in context of a lesbian couple? So clearly the government tried to take the case out of our hands and did all of this kind of fear mongering, which they were succeeding at because of the vast nature of prayers and issues that other petitioners had reached. For example, some petitioners had actually asked for reinterpretation of these things. And so the government was right in saying that it's not just a simple matter of recognizing marriages under the SMA. You have to interpret everything. And the court does not do a job of interpreting all laws in one case. This will obviously become a legislative exercise, so the parliament should do it. And the bench was agreeing with them. So we were a little shaky in the middle of the proceedings. And lastly, the implication of personal law, which I'll deal lastly. And so the court started agreeing with the government to such an extent that they started thinking out loud to suggest that we will not touch marriage at all now, because this seems very complicated. Why doesn't the government constitute an interministerial coordination committee, like an IMCC, which was done during the Nalsa case, so that the government can just provide administrative relief to cohabiting couples, and we don't have to do anything. So now we were really in trouble. So our job in the rebuttal, which is the last stage of the proceedings, was to try and narrow the scope of the hearings so that we can reach the best possible outcome. So one of the ways to do that was that all lawyers had to have a meeting to agree to a common minimum strategy to say, let's leave out the complicated and unrelated issues For example, the succession to property and the access to maintenance, which is a gender-specific provision. I'll just briefly talk about this aspect of what do you mean by gender neutrality of law. So some of the petitioners talked about that if you just read all laws gender neutrally, it will automatically include queer trans people, and that is the best possible outcome we can have. But it's more complicated than that. For example, under the Special Marriage Act, under most of the marriage laws, except the Hindu marriage law, maintenance is a gender-specific duty, meaning the husband is obliged to pay economic security to the wife. If you read such a provision gender neutrally, in interest of a lesbian, gay or a trans couple, what will also end up happening inadvertently is that the heterosexual woman will be liable to pay maintenance to the heterosexual husband. And looking at the social economic conditions of women in India, that's an undesirable, adverse consequence. So then our job was to tell some of the other petitioners in the case that please don't touch this issue right now, because you're going to, it's going to be one step forward, two steps back. You don't want to win queer trans rights on the backs of women's rights. So you leave this and you can re-agitate this 3 months later. The image over here, the illustration is supposed to go with the second point, which is the notice domicile objection. It's only the secular marriage law which provides this. No other Hindu, Muslim, Christian, Parsi marriage law has this, which is that if, for example, a Hindu person and a Muslim person have to marry under the secular law, you have to, one of those parties has to give a notice to the local marriage registrar. That notice is published in very public, conspicuous space with the intention to alert the family members and the public at large whether one of the parties is cheating each other. So, and if they are, then somebody can come forward and oppose, object. That is the intention of the law. But if you see, interfaith and intercaste couples have been harassed and killed precisely because of such kind of provisions in law, where the law encourages such kind of undue interference in private lives of people. And given the history of natal family violence against queer trans people, we were arguing before the court that this should be struck down not just for intercaste, interfaith people, but also for queer and trans people, because it's not the intention of the law that matters, it's the impact the law has on the ground that is material, and that's the standard how courts also reinterpret things. And lastly, we were just arguing for the court that you don't get too caught up in these complicated questions of the personal law or the gender neutrality, because courts have powers to separate issues and touch on only one aspect, limited aspect, without disrupting or making the other parts of the law infructuous or unenforceable. So yeah, the matter then concluded on 12th May. Case has been reserved for judgment, which will come anytime between July to October in the next few months. And best case scenario we are looking at is the court recognizes queer trans people's marriages and other issues that we are argued in the Rituparna case. Worst case scenario, I think, is they don't touch marriage because they're confused and they think too much rewriting of law will be required. So they won't touch marriage, but they'll issue equality, non-discrimination, right to choice, all these kinds of constitutional declarations, and ask the government to issue administrative relief or amend laws to protect LGBT families and the other issues of chosen family and protection from violence like we argue. That we can have questions if there are.
So do we have it?
We'll step forward.
One by one.
I'll give it to, no, I'll give it to you.
The reason I'm standing there is because all the slides. So
Sham.
Hi, good evening.
Good evening.
Priyank here. So, I'm so sorry I got a little late to get in, but from the little info what I got from you. So, according to what the code is trying to do is right, they're trying to certify what they can give at the moment and provide relief to the community, and later on we can enhance it, and that power goes to the hand of the government, right? Isn't it so? That power goes into the hand of the government to enhance the further rights of the.
It can be left to the government, and if the government fails to do its duty, say within 3 months, then we have the power to go back to court and say, issue contempt, and now you enforce because the government has failed to do this.
Okay. See, I'll bring to the question, okay? So I teach 9th and 10th standard kids, right? So because it was so much into news and they were watching at home, So the kids came to me in the school and I'm out to my kids in the school, So we were having a conversation. They were like, sir, but it is the job of the legislature to make the law. This is what Obama did in America, right? So I said, I'll not get into the detail of it. It is beyond your, understanding right now. And the court's job is to do the interpretation part of it. So I said, the court is trying to interpret the law. That's only right now. There are, privileges and rights which comes to us as a citizen of the country, and the government is not wanting to give it to us. That's what the whole fight is right now all about. Okay. And my question now is, are we as a community ready for this? First of all, because
By this, what do you mean this?
by the Same-Sex Marriage Act, right? There, as you said, we'll not touch this, will not touch this, will not touch this. Okay. Domestic violence with women, that is very much understood. The couples who are staying together from the community, okay, there is so much of violence which happens to the submissive partner, okay, and the submissive partner cannot go to the court, cannot go to the police station, he cannot go anywhere. So once this comes into picture, if I'm having a clarification of it, the partner, the other one, okay, he will be legally binded and the partner can go to the jail, right? If this happens. Like
In terms of intimate partner violence.
Yes, right.
Yeah, I mean, also recognized in non-marital context under the domestic violence.
Yeah, but then this will give an enhanced kind of
More liability.
yes.
Protection.
So those who are staying together, they do all this because they don't the kind of violence they show to the partner because they know some way that legal binding over us is not yet strong.
No, what we need to say is without a marriage right also.
Yeah, I understand that. That's what I said. If it enhances the right, the partner will have some more rights, right? Today it is just a common citizen right what we have, But then tomorrow when you become a partner, like a legalized partner out there, right? So
Right.
this will have more enhanced right when it comes to under the same kind of domestic violence act or something like that. Isn't it so? So how does that will work out?
So if I understand your question correctly, you're saying, say, for example, take a gay couple.
Yes.
If there is intimate partner violence,
Yes.
what remedy does the victim have, and what penalty can the aggressor have?
Yes, because in women's
After
case,
marriage or without marriage?
yes,
Is
that's
that
my
your
question. Yes. Or during the proceedings, have you all got something like this up?
And he's asking, will it enhance more power to the victim if the marriage right?
So, keeping in with the cultural, legal prioritization of marriage in law also, married parties in law do have additional protections from violence in criminal law. The domestic violence law covers married as well as unmarried couples, currently still largely heterosexual. Very few orders of course recognize lesbian or persons in queer trans relationships, and that is a civil law where the remedy is, where the punishment is not prison but protection orders for the aggressor, to say the court basically telling the aggressor that you desist from committing acts of violence against the partner. If this order is violated, then prison is a consequence, yes, but that's not the first. In terms of, say, we talked about 304B, there's 498A of the Indian Penal Code, which is about married women seeking remedies against cruelty by husband or husband's relatives, and that's a criminal provision where husbands and husbands' relatives can go to prison if convicted under the law. So, yeah, marriage does lead to harsher penal consequences also. I mean, if I...
That was my question. Is the community ready? Because everybody likes, nowadays we don't like marriages, we like weddings, as the concept says,
I'm not sure if I understand the question.
No, so that's what.
I got my answer. So legally, I got my answer. Okay? It would go like this.
It's more of a personal asking if we are ready for marriage.
Because
I mean,
we do not
yeah,
understand the kind of the answer, the justice.
With rights also come liabilities and
Yes,
responsibilities. So
right?
there will be a
Yeah.
like one of the first consequences of any kind of legal recognition, not just marriage, will be the duty to pay maintenance to the queer or trans partner. So that's a duty. Where there's a right, there's a duty as well between the parties.
Hi, Harish. I think if I'll just one line. So, is the community ready? I think more than that, is the individual ready to get married? Is what is needed. And I think So within the community, you have people who are willing, not willing. I think I'm not willing side. Anyway, I had a bunch of things, and thank you so much for this. I think it brings in a lot of clarity and complexity at the same time. When you presented here, I'm having a lot of conversation in my professional space, personal space, of course, on the topic, and a lot of people, well-wishers, but half-baked, substances. People are coming to me and they're asking me like, is marriage really needed? Because it's a very spiritual thing. So to them, I'm going and telling that no, it's a very contractual thing too. With marriage comes a lot of things that's important for two people and all. And then I hear back in the Supreme Court conversations where even the panel, I don't know what to call all the
Judges.
the bench is also saying that no, it's a mix of the two and everything. So how does one in today's day and age define marriage, and is it contractual, is it spiritual, is it this khichdi of the two, and at the same time, how do we go ahead with this, as you were saying, the good part, like the best situation right now is that we get marriage equality, the worst is that we don't. What is there in between? Like, are there different avenues that they take apart from going to the parliament? Like, will they give something like a civil union? If that happens, what does it entail and what does it not? I think I've asked a lot of questions.
I think most broadly two questions you asked. I'll respond to the second one first.
Sure.
So if not marriage, then I already indicated that the bench might give constitutional declarations that any two persons, or say any persons, have the right to reside and form families irrespective of sexual orientation, gender identity, and no government authority or police or any private authority can interfere or violate such rights. For example, we are hoping that if not marriage, then for example, as an example, what they might say is that a live-in gay couple also has the right to jointly adopt a child or to transfer property to the partner without incurring undue tax implications that otherwise heterosexual married people don't have to go through. As example of that. So either there is marriage, or the expectation is that marriage does not become the barrier to seek and access rights.
Okay.
So, I mean, and we can only say this based on what happened in court. Now the court might come up with a third alternative, which is at best known to them, which we'll only know when the judgment is out.
Yes.
But we can only speculate and predict based on what is publicly known and what is known in court. Your first question, the spiritual, contractual part. So one of the government also argued this in court, right? And in their written submissions also. Not just the spiritual, contractual nature of the relationship, but the fact that marriage has historically always been a heterosexual, monogamous union, which is intended to lead to procreation and perpetuation of the race. This was argued in the court by the government side. And so there is this attempt by the government to give this very fixed, rigid, unchangeable idea of what a marriage is supposed to be in law or in Indian history, society. So if you just look at Indian history or even trace the developments in law, and you see if that stands up, What we did in court is to respond to such kind of arguments, is to say that marriage in fact has never been fixed, rigid, unchangeable, even for heterosexual people. If you only look at the Special Marriage Act's legislative debates, 1952, 1953, 1954, what the parliamentarians are talking about, they themselves are talking about this as a response to the fact that because society is evolving, law should evolve to recognize interfaith marriages under the Special Marriage Act. And how they came to this realization is to say that look at the history of the heterosexual marriage institution, and so much has changed. Sati was legal once upon a time. A law had to be passed to prohibit sati. Child marriage was legal once upon a time, where children as young as 7 years of age were legally married off. A law was brought to prohibit that as well. Adoption, right? If there was a infertile couple or people unwilling to sexually reproduce before 1956, such persons would have no authority to adopt a child. But that changed in 1956, and with all these changes, the meaning of family itself changes, right?
Yeah.
In 1956, the law decides that a husband and wife can legally bring in a member of a minor within their family unit, and from this day onwards, that child is for all intents and purposes their equivalent to their biological child. Will inherit their property, will have all those other rights of performing their last rites and everything. This itself changes the notion of what a family is for heterosexual people also. And there are countless such examples. For example, monogamy was also something that was legislatively enforced on Hindus. Before 1955, Hindus could remarry, have multiple wives by law, because there was no prohibition against it. So the Hindu Marriage Act of 1955, for the first time, legally enforces the concept of monogamy. Divorce, Indian Christian Act of 1869 or 1871 brings the concept of divorce for the first time in Indian law. So the fact that before 1955 a Hindu man could have 3 wives, but after 1955 one Hindu man, one Hindu woman, that has changed the institution of marriage, right? So this is how we presented the arguments to court, to say that the institution of heterosexual marriage itself has also undergone a vast sea change. So why should you now stop only at the threshold of sexuality and gender? This is just one more step in the evolution of the institution of marriage.
Thanks.
Just a follow-up from point you made, that whether it's a spiritual or a contractual relationship, right? So was there any petition or anything which purely considered this as a contractual thing, in the sense other countries have a concept of a civil union, right? So can the Special Marriage Act or some act, can it be interpreted in a way to recognize civil unions, or will that also have to come from Parliament?
So interestingly, when you speak of civil unions in the Indian context, we already have a civil union in India, which is the Special Marriage Act. In the foreign jurisdictions where we get this language of civil unions, those concepts come because, for example, in the US or in UK, marriage laws are only religious in nature. And when questions of queer trans people wanting recognition before law came, and the parliaments or the courts decided that we can't accommodate them within Christian or Jewish personal laws, then so we'll evolve a civil union where we'll allow 2 lesbians to solemnize that and register that relationship, which will take care of them, their rights and duties towards each other as partners, right? In the Indian context, since 1954, we already have a civil law where, to recognize the ability of a Hindu and a Muslim, or a Parsi and Muslim and all those other permutations, because under any personal law, under Hindu law, only 2 Hindus can marry. and so on and so forth for Muslim, Christian. So to allow Hindu and a non-Hindu to marry, the Parliament already introduced the 1954 Special Marriage Act, which is in a way a civil union law, divorced from religious, social, cultural norms. So on that conceptual level, there is a civil union in India, but in terms of that contractual recognition of rights, I think the closest that the hearing came to was in terms of what we are asking in the Rituparna case about the chosen family declaration, and how a consequence of that should be that I should be able to nominate my sister for one thing, my partner for one thing, and my friend for something else. And these are all persons of vital importance in my life. One is a sibling, one is a friend, one is a romantic partner. There can be a fourth in a different context. So, and I recognize the authority of each individual to separately govern different aspects of my life. Given the history of natal conflict and the fact that queer trans people are documented to largely not just India but outside India form chosen families. So what is already existing is sought to be recognized in you. That we are not creating something new. We are only saying that what already exists, you should recognize that and protect those people.
I have a question. Even if we don't get marriage equality or marriage recognized, like recently in Nepal, if you married somewhere else in some other country, your marriage is recognized, and which in India it does not recognize if it's a gay marriage. Do you think is the chance of we talking about those on was that?
But we had some of those cases in the Supreme Court now also, where I think the leading case, if I'm not mistaken, there are at least 2-3 cases of like this of this nature before the Supreme Court right now, where it's gay couples. There are at least 2-3 gay couples who have married abroad and are choosing to now come back to India, but obviously as per Indian law their relationship is not recognized. So the challenge that they have made before the court is to say that the registration tool that is there to allow, for example, there's the Foreigners Marriage Act. So Foreigners Marriage Act basically obviously recognizes heterosexual marriages of people performed in abroad and coming back to resettle in India. So they've asked to reinterpret such laws also to say that gay couples who've married abroad and are coming to India should be recognized by reinterpreting such laws as well. I mean, this was done, but it's anybody's guess.
We'll have to come the next one.
So while reading the news, I got to know about this concept called as same-sex marriage is elite class thing. So I talked, but I checked, there are only marriages like transgender marrying a man. But how did we argue for this one? Do we have any stories to counterattack? Like, I don't hear any stories from rural India or villages where a guy is marrying a guy, a female is marrying a female. So how did we counterattack that?
So if you go through the Rituparna Bora petition itself, which is available, if you Google it, it's available on several links. If you look at the Rituparna petition, I started by saying that we are, apart from the 4 queer feminist activists, we are representing 3 couples. And all these 3 couples come from rural India. And the formation of these 3 couples is also, one is a woman, one is a trans masculine person in all 3 relationships. And these are all people who've come from somewhere in West Bengal, somewhere in Punjab, and one in Bihar. Correct. So this was there were people from non-elitist, non-urban context before the courts. Some of our friends who also came before the court also represented a runaway lesbian couple, one of whom is an OBC woman. That lesbian woman is OBC. So, of course, when you bring such examples to the court's attention, this is one way to shut down those kinds of arguments that marriage equality is an elitist, urban-centric concept. I mean, we were saying that for rural, marginalized, queer trans people, marriage is also necessary because once a person has married into a family, there is a severance of legal ties with the birth family, right? And given the history of natal family violence, marriage presents one option for somebody who's just touched adulthood and are contemplating exiting their abusive family. And if they have a romantic partner, if the court agrees with this, they have the option of legally marrying that person, and only those people are now responsible for each other's rights and duties. The parents, relatives can no longer interfere. This is in context of married people. Similarly, in context of chosen families, you give them the authority, where single people should have those options, that marriage should not be the only way to exit an abusive situation. That if I'm single at 25 or 35, and if I'm facing natal family conflict, I should have a friend or a safe house or a group of people who are of vital importance to me, who I can assign rights and responsibilities to.
So I just want to add to the point on the urban elitist idea, because I think I'm really glad you asked the question. It's the way the story has been told and the way the media has been pitched the story, it only represents those kinds of voices. And it is such a huge disservice to the LGBT community. Because I think what Suraj spoke about, the report he mentioned, Apno Ka Bahut Lagta Hai, that 2 days in New Delhi where people came from small town India to talk about natal family violence, no one was elitist there. And that is also before the court. Unfortunately, what is happening, I think, in certain contexts in media today is that there's a very, we want to portray a very, comfortable notion of what it is to be gay, etc., or certainly a very westernized kind of idea of it. Whereas queerness is, across the country manifests in all kinds of amazing ways. I think I want to just go back for a few years prior. It's one of the pet things that I try to talk about. The 377 case, you all might have read about it in the recent past as the case where this person called Navdeep Johar and this restaurateur called Ritu Dalmia, etc. came to the court, and their lawyers fought for us. They were not in the picture for the first 15 years of this case at all. They came in 2016, they contrived, they hired a PR firm, they did the whole media thing. Many of us have been involved in the case since 1999, 2000, 2001. The people who were first, the queer people who were first in the courtroom before the Supreme Court was a person called Kokila. Kokila is a hijra from Parvani from Bangalore. She speaks about, in the most powerful way that no one can even come close to really, about how her criminalization affects every moment of her life. Now to give the picture of, oh, we have these cool gay people who are restaurateurs and dancers, etc., you had a totally different story emerging. And I think one of the things the Bora petition does, amongst other petitions, is to try and bring that other reality to the media's attention, because not all of us are elite and most of us are not. Most of us are living very complicated lives actually, and I think those need to be represented. So one of the things that you mentioned in your presentation today, I think, was also that there was a kind of a narrative being given to the Supreme Court that, our lives are perfect except we need marriage, which is so far from true, and that's again something you all try to complicate in the courtroom, and the judges picked up on, I hope.
I'll just add one more point to that. This understanding of who is elite and coming from a place of elitism, how does that influence your decisions and what you want from law and from the courts? So, I mean, on one level, I don't fault the government and don't fault the court never said this. The government said these things and the media might have just reproduced that. But I won't fault the government, because we did have petitioners before the court who did come from that very upper caste privilege, and that influenced how they wanted to, what kinds of outcomes they wanted from the court. So, for example, while we were talking about the ability for two people to marry or to have chosen families and have protection from violence from families, there were people for whom, in fact, the narrative was not just that our families love us and everything's perfect except the law doesn't recognize us and we just want marriage. They wanted marriage and property and economic security. And if they wouldn't get that at this stage, they were willing to even risk the entire case, which is exactly urban elitism of that sort, that you are willing to sabotage the entire case for where now, because people like these petitioners which we represented had come to court, and it wasn't just a stronghold of 3-4 people who were representing urban couples, for them to ask and pester the court consistently despite the court's reluctance from day one to go into personal law, into gender neutrality, for them to do that does reek of that kind of privilege and elitism, which could have almost jeopardized the case. And I mean, we still don't know how the court will decide the case because of such complications that came before the court.
We'll go with last question.
Hey, hi, good evening. This is Souvik. So I am currently working in a IT company, and you know that when the Pride month comes, and there is like all of a sudden your office turns into a rainbow factory and all those things. So now our office also has that queer-friendly environment and all those things. So last year, what happened? That same thing happens, and then our year-end, this Mediclaim thingy comes to the picture all the year, right? Yeah, the year-end. There was mentioning that whom you can include in your Mediclaim, right? So there is like your family member. Family member, they actually quote that your spouse, your parents, and your children. Suppose my question is like, when you are not having a family, like whom are you calling that definition of a spouse? Suppose if the court is not acknowledging your marriage and this is a civil union, will that be like highlighting these points? Like will that be a loophole there, that because I am not married to a person, who, I mean, this is a civil agreement or something. So will these things of like these kind of things will be resolved there? Like, what do you think on the legal aspect?
So we did bring one aspect of what you are talking about before the court's attention. When we talk about chosen families, one of the examples we gave was in the context of healthcare. One is the Mental Health Care Act that we talked about, where you can nominate any person, not just family. The other is now you have Supreme Court guidelines on passive euthanasia in this country. Basically, which was first decided in 2018, where the court says that if you're in a terminally ill state and further treatment is not going to be of any help, so that person, that patient, has the authority to decide whether to continue seeking treatment or whether to discontinue treatment at the risk of death. Right? The Supreme Court recognizes this authority of terminally ill patients. Now, in that context, the court said in 2018 first that before you actually become terminally ill and you're unable to make any decisions for yourself, when you're of conscious sound mind, people have the authority to execute advance directives, where any person can basically write down how, if they reach at a stage of a permanent vegetative state or a terminally ill state, where treatment is no longer going to progress to a good condition, then you get to decide in that document that you execute that who will take that decision on my behalf in my best interests at that stage, and who is only allowed as per law to take those decisions as of 2018 was guardians, close relatives, and family members. And family is, like you said, broadly, usually typically defined in law as persons related by marriage, blood, or adoption. So basically all blood ties, right? In 2023, in February, the court has revised those guidelines because they found some aspects of it to be unworkable. And one aspect of that has been that where some terminally ill patients have not executed advanced directives at all. So what is the doctor supposed to do in that state? Like, who does he have to consult to decide, should I withhold treatment or should I continue administering treatment? In that case, the court has now declared that you don't only consult family if they're available, but you also consult next of friend. So these are ways in which the law is slowly expanding its horizons of who can be considered as a rights bearer, as a duty performer in healthcare context or otherwise, slowly, step by step. And so all those 4 examples that we discussed in terms of adoption, mental health care, Ijra Gharanas, and this advanced directive example, I mean, there are already 4, one is too many to recognize the authority of law to go beyond sex and blood. But there are 4 very strong precedents in law that we've presented to the court to say that what is done in these specific contexts for people, including Ijra Gharanas, we are just asking that to be replicated in general, everyday affairs of lives context for queer trans people. So these things happen incrementally.
So we have one more last question.
I'll quickly wrap up, like, not a long question, but you mentioned about like natal family violence, and I speak as a trans woman that somebody who experienced that, and at the same time, like, my question is like, when you file these petitions where they talk about like this is like an escape from natal family violence, maybe this is a protection, like having a partner or being recognized. What if I don't want to be recognized or codepend on like a partner for my safety or for my ambition for that matter? So why is there no petition that actually raises questions about protection from natal family, but more legally, like not just like this assumption that there's violence that comes from natal family, so let's just like get her married. Why is there no resistance towards, like more legal resistance towards natal family or like harsher laws that protects trans people? Thank you.
I think the issues that we raised in terms of recognition of chosen family and the consequential relief flowing from such a recognition might respond to the concern that you're talking about. Like, I might be queer or trans and still living with my natal family as an adult, and I may not be facing overt acts of violence, but there is covert acts of silences, neglect, denial, right? Because of which, if I have to seek admission or undertake financial transactions for professional, educational reasons, and I may not have that kind of support from my natal family as an adult. So that's where, if the court agrees and accepts our arguments on the recognition of a chosen family, in such context, then you have a friend, or not a partner necessarily, a friend, or anybody of any vital importance, could be a professor, could be a colleague, whoever you trust, and you can have a reciprocal relationship of sorts in that manner, in that context. So I suppose does that respond to what you are thinking about?
That's like pretty much like you answered. What I wanted to ask was basically, why is there no petition that talks about resistance or like introducing laws that actually holds family accountable instead of like just like kind of pushing under the bus that maybe your friend, maybe like, because I see that maybe I don't have a chosen family, not because I'm hyper independent, because I have CPTSD, but in these kind of cases, because it is like evident in history that trans women have never been recognized in marriages or relationships, and that's been evident because most of the petitioners who were representing, they were either trans queer or lesbian queer. I'm talking about binary trans women. You'll never see them in these courts because there is no partner that will actually show up with them. So in that case, like, it makes people like us very isolating. So, and also like if you are not so connected or well connected with the communities as they came. So exactly where should you seek protection or safety in that regard? Because natal family is also kind of creating this issue, and you don't have people in the community also supporting because they either think of you as privileged and all of that. So where exactly can we also find safety?
No,
In
so
that
you-
cases, yeah, because if I don't want to get married, and if I want to stay single and I want to live my livelihood, I want to earn my livelihood. But in my experience living alone, I'm living here in Pune, it's 2 months. But the only question that was asked to when I was looking for houses was, why aren't you married? And my answer was like, I was kind of like jeopardized because it's not like I'm against marriage or I have no ambition, but I don't have a partner. And in that case, like, I'm always looked down upon, like, by character or by virtue of my being. Mostly it's always considered like you must be a sex worker or whatever. So like, how do you like think that we should reintroduce this bill where these aspects are also kind of taken into account? Thank you.
I understand what you're saying. So in fact, in some of the social media discourse that our petitioners were engaging in during the case hearings about the chosen family aspect is to reframe it as the right to exit natal families, which was not obviously argued before the court because you don't want to be seen attacking the traditional family unit so aggressively before the court, where you have to phrase because court strategy, you can't go before a court and just ask for everything to burn down because
we have evidence that people have been murdered, that they have been likely to be pushed under the bus. So what more do we need to challenge certain things that actually becomes like a direct subject to our mental health, personal safety and the social safety?
I understand what you're saying. So you should keep in touch with the national network people because they do. This is just the beginning, right? The recognition of chosen family and the chosen family thing is about getting more autonomy for single people. It's outside the context of marriage. It's outside the context of conjugality. It's about single people. If you read the petition and what we discussed. So, and this is just the beginning. And because they frame it as the right, like you said, to lessen the control of natal families on queer trans people. So this is just the beginning. Maybe you should keep in touch with the national network people and carry those conversations forward because everything happens on a step-by-step basis. We can't do everything once. We were pretty ambitious in this case also to ask all of these things because mostly because of the fact that the Chief Justice is understood as an ally. So we went. This was also quite ambitious, by the way, for this case. Otherwise, everything was only about marriage.
All right, so we are running out of time, so I'll be cutting down questions now. So going ahead, I would like to thank Advocate Suraj for being here. I would like to call Ram down to you. Thank you. We finally got you the concept of this.
So I just have a answer to your question, not from the side of law, but if your company is not giving this basic benefit, every company or corporate has the authority and power to question this medical health partners or demand these health partners to provide this basic benefit of adding irrespective of gender as a spouse, right?
And
not doing that.
we will have a panel discussion tomorrow about corporate inclusion, so we'll take that question up there. Sorry about that.
If they're not doing that, then they're just doing it.
Also, I would like to once again thank you all for being at the Out and Loud Pune International Queer Film Festival. We have our last movie going to be played now, so I would request the team to continue to play so that we do not waste time. We have crossed a bit of time. In 5 minutes we have crossed, so that's okay. We won't get you